Hello and good afternoon friends, welcome to the CEC-UGC live lecture. Dear friends, as you know that from time to time we talk on different subjects, we talk on different topics so that it becomes easier for you to get in-depth knowledge on various topics, various issues. So dear friends, in this session today we are going to talk on Indian Executive and President. For this discussion, dear friends, we have again with us in our studios Dr. Satish Kumar Jha. Dr. Jha is Associate Professor in Department of Political Science, Aryabhat College, University of Delhi. So dear friends, let's welcome our guest, Dr. Satish Kumar Jha. Dr. Jha, welcome to the EduSec lecture.
Thank you, Geetika ji. In fact, today's lecture we are going to have on the executive, political executive in India, and while discussing the executive, we will especially focus on the office of the president. But while discussing the office of the president, one has to discuss the overall architecture of Indian democracy, that what type of position president occupies in Indian democracy. Now, as it is well known that democracy functions on the support of the three different organs, legislature, executive and judiciary, and there is also the example of United States of America, where you have the separation of power doctrine basically influencing the entire working of democracy there. Though of course, it is a debatable question that whether the similar type of separation exists in India or not. This matter has been addressed by the judiciary also, but fact of the matter is that we do not have watertight compartmentalization like United States of America so far as the separation of power doctrine is concerned, but nonetheless all three spheres, the legislature, executive and judiciary in India, have been assigned their respective rules, and they are supposed to function as per the spirit of the constitution in their assigned sphere and according to their assigned role. Now, if we go according to that principle of the constitutional allocation of powers, duties and functions, then President of India occupies very important position here. Now, one thing is also perhaps needs to be remembered here, that the office of the president is basically a symbol of two important features of Indian polity. One, that India is a parliamentary democracy, and two, that India is also a federal polity. And the president, the office of the president basically combines the features of both federal as well as parliamentary thing, and therefore this office is quite significant. Now, we will see in course of our discussion that how president symbolizes both the parliamentary as well as federal, and that is perhaps a unique thing in the sense that it is only in the Commonwealth democracies, erstwhile colonies, and today we can say the Commonwealth constitutionalism. For example, in Australia, in Canada, in New Zealand, in India, we have this such combination of parliamentary federal features. Whereas the classical case of this federal presidential system in United States of America, whereas the parliamentary system is Great Britain. But India combines the features of both, and therefore it becomes significant that this office of the president has to function according to this constitutionally assigned important role in both spheres, the federal as well as parliamentary. How it happens and how it accomplishes, how this office accomplishes that task, we will basically try to have a look at it in course of our discussion. Now, the president as a symbol of the president parliamentary system is best reflected in the fact that the two houses of parliament, the legislature in India, is defined as the two houses of parliament and the president. So, president is integral to this entire definition of legislature in India. Now, that means that no act of parliament is basically complete without the assent and signature of the president. So, when we basically define parliament, when we define the act of the parliament, that includes the presidency as well. So, therefore, he becomes an integral part of the legislature, and therefore, he has important role to perform so far as this parliamentary system is concerned. Now, in fact, as it is well known, the parliamentary system functions on basis of the concept of the cabinet system, the council of ministers, and executive in that sense is created by the legislature. Now, you do not have the separate election like the presidential system for office of the prime minister, that whosoever is the leader of the majority party in parliament becomes by virtue of the fact that he is the leader of the house also prime minister, because he is invited or she is invited by the president to that office. So, this is integral, this is basically important feature of the parliamentary system, and therefore, the Indian constitution, borrowing that principle from the British system, what it does, that article 74 clearly lays down that there will be a council of ministers headed by the prime minister to aid and advise the president. So, basically the council of ministers headed by prime minister will be there to aid and advise, but it will be basically the aid and this advice will be rendered to the president. This is basically the constitutional position, but fact of the matter is that in parliamentary system, the prime minister, the council of ministers, the cabinet, they are the real executive, they are the real wielder of power, and the president, head of the state, is only a symbolic head. So, therefore, as it is commonly understood that the British monarch reigns, does not rule. So, similarly one can say that Indian president reigns, but does not rule. But the fact, the case in India is little bit different from what we normally see and understand in context of the British system, because of 2-3 reasons. The first, that Britain has a written constitution, India has a written constitution, and it has been clearly mentioned that 74 that the British, there will be a council of ministers headed by prime minister to aid and advise. Similarly, there is also an article 78 where the council of ministers headed by prime minister has to report to the president about the conduct of administration and his government from time to time. And if the president so desires, then he or she can also ask the prime minister to report about the conduct of the government. So, this relationship therefore is little bit intricate and different from normally what we understand the parliamentary system as as a classical case existing in Britain. And therefore, it has given rise to number of interpretations, conflicting interpretations one can say. In fact, the first President of India, Rajendra Prasad, who was also the chairman of the Constituent Assembly, he in fact believed that the office of the president in India is not replica of what normally you understand by British monarch, office of the British monarch in a parliamentary system. And he believed that because Indian president is elected, it is a republic, therefore, the head of the state is elected head, unlike the Britain where it is a monarchy, limited monarchy maybe, and therefore, it is hereditary, and therefore, the position of the two, the British monarch and Indian president cannot be compared. So, this was the opinion of the chairman of the Constituent Assembly, who later on became the president, first president of India. And the situation, and this matter did not die with the first president. This keeps coming up again and again. On several occasions, we have seen that many presidents have expressed similar opinion, if not exactly in the same language, but nonetheless tone and tenor have been the same. And therefore, we have had instances later on when some of the president in fact wanted to give this impression that the president also has a real power. And normally people cite the example of one of India's president, K.R. Narayanan, who defined himself as a working president, that I am working president. That means the president can also have some effective power in terms of the promotion of democratic polity, democratic governance in India. So, therefore, this is one important thing, that the parliamentary feature as reflected in this institution called president has been a matter of debate and discussion, that if the president is integral to parliament, the two houses of parliament and the president, this is how the parliament is defined, then what are basically the constitutionally assigned mandated role for the president. As it is well known that president has many roles to play so far as the conduct of the business of parliament is concerned. Basically, he summons, he prorogues the house. In fact, president acts through the speaker and the chairman of the Council of States. Of course, the Vice President of India becomes ex officio chairman of the Council of State, that is Rajya Sabha, and Lok Sabha elects its own speaker, that is presiding officer. So, President acts through them, House is conducted by them, but the President has important role to play here. Now, after constitution of the Parliament at Lok Sabha, there is a joint session and the President addresses. Every year, the beginning of the year when Parliament meets, President addresses. So, I mean, these are the ceremonial occasions, these are the moments where you get this impression that what role President plays in the life of the legislature. But it does not stop there. In fact, there are many more dimensions of this role, and therefore, when we come to this office of the President, and particularly if we look at it from the point of view of the parliamentary system, then basically we have to see that how President becomes extension of this legislative wing of the polity, in the sense that legislature is incomplete without President of India. Now, therefore, what we find that the kind of power the President has vis-a-vis the Parliament are quite significant here. For example, President has legislative power, President has vetoing power, President has many other executive powers, of course subject to the ratification of the legislature. For example, before we discuss other powers of the President, let us first of all discuss his legislative power. Now, the legislative power starts with the legislation of the Parliament, and as it is well known that the money bill cannot be introduced without having the signature of the President. I mean, or it is only President who on whose behalf or whose approval the money bill is approved, introduced in the Lok Sabha, because as it is commonly understood, the upper house does not have much say on the financial transactions, legislative transactions. Other acts of the Parliament also become basically law or acquire the stature of a law only after it gets the approval and signature of the President. But that does not stop there. The President also has vetoing power. The President vetoes legislation. And of course, when we talk of vetoing power of President, then there are different types of vetoes in India as well as and in other countries also. In fact, the vetoing power of President at times is seen through the prism of four different types of vetoing power, the veto power which other presidencies have. For example, the four different types are absolute veto, qualified veto, suspensive veto, and the pocket veto. For example, it is believed that the British monarch has absolute veto, but basically that veto is seldom used because the British monarchy does not have much role to play vis-a-vis the legislature or the council of ministers or the cabinet. But the qualified veto is basically attributed to United States President, because what happens in qualified veto, that President can veto, but the Congress, that is American legislature, has the power to override that veto with 2/3 majority. So, therefore, it is qualified. Now, suspensive veto is also a vetoing power of the presidency, where ordinary legislation can basically override the veto of the President, then it is called suspensive. And normally it is believed that it is the French President who basically can use this suspensive veto, that he can veto or she can veto, but it can be overridden by ordinary legislation. Similarly, the pocket veto again is attributed to American President, because in case of United States of America, what happened, that there is a 10 days clause that if the Congress is adjourned, and he can, and this whatever legislation is passed and the President has vetoed it, and if it is not overridden by the Congress and the Congress is adjourned that 10 days, then the President can basically he can use it to kill a bill. He may not give his approval or assent, and therefore the bill will die a natural death. So, therefore, this is a pocket veto, that he may simply kill it by putting it in his pocket because of this 10 days clause. Now, Indian President therefore is believed that has a combination of absolute, suspensive and pocket, all three, and therefore, this is very important legislative power of the President of India. Now, absolute like British monarch, but like British monarch never uses it, Indian President of course can use it. For example, absolute veto of Indian President is normally believed is available vis-a-vis the private members bill. Secondly, if a ministry resigns, and the next ministry comes into power, which may be or in a situation where it may like to oppose the already legislative act of the previous parliament, then it may advise the president to use the absolute veto and not to approve it. And then you have the suspensive veto, because the suspensive veto is like like French president, where the parliament can again legislate or again send it back with the ordinary majority, and basically then in that situation president normally has to assent it. But interestingly, the most interesting aspect about this vetoing power of president is the pocket veto, and the pocket veto basically president gets by default, because constitution does not prescribe any time limit under article 111, and therefore, in absence of any prescribed time limit for the return of the bill, so far the president is concerned, it is written as soon as possible, and as soon as is basically the discretion of president. So, therefore, what he can do in some situation, that indefinitely he can sit over this bill, and therefore, it can be said that in such situation he may be very close to using this pocket veto the way American president uses because of this 10 days clause. Now, what happened, that this pocket veto normally the president can use when the government is shaky, when there is no clear cut majority, so on and so number of eventualities and contingencies can be thought of, but nonetheless, because of no time limit prescribed, the President of India can use this veto also. So, therefore, interestingly what we find, that so far Indian President is concerned, he has the combination of all three: absolute, suspensive and the pocket. Now, coming to this apart from this vetoing power, there are many other legislative aspects of the presidential power, and another important aspect is what normally we believe, the ordinance making power, and this is basically coextensive with the parliament, that basically the ordinance has the same force as the act of the parliament. So much so that when the fundamental rights chapter define basically law, that what is law and what type of laws can be invalidated by the judiciary if they encroach upon the fundamental rights of the citizens or fundamental rights of the people, when defining law, that definition also includes the ordinance. So, therefore, ordinance has the same force as act of parliament or the legislative act of the parliament. Now, what happened, that this ordinance making power is of course available to president on this premise that some contingency, some emergency may arise when none of the house is in session, and if none of the house is in session, then what happened, that the president can issue this ordinance. Now, what happened, that this ordinance making power of president, of course, there is a rider, that within 6 weeks from the date of the reassembly of the parliament, this ordinance has to be put before the parliament and needs approval. Now, what happens, that sometimes it is also believed that the two houses can be prorogued, and finding this absence of the houses in session, the president can use that opportunity to promulgate ordinance. So, therefore, ordinance of course is also a controversial power with the president, but the design of the constitution is different. It was basically given to meet certain contingencies, certain emergencies, certain eventualities, that when the houses are not parliament and there is something very urgent, then in that situation president can promulgate this ordinance and the ordinance will have the same force as the law passed by the parliament. Now, of course, this matter also has been reviewed by the judiciary, by the Supreme Court. In the famous Cooper case, what the Supreme Court believed, the genuineness of the president's satisfaction so far as the promulgation of ordinance is concerned could be challenged. Okay, because whether the satisfaction is genuine or not, the genuineness aspect can be looked into by the judiciary. Now, what happened? For example, as I mentioned, that if house has been deliberately prorogued, or president has created a situation where basically the parliament has not been given the opportunity to enact a bill, and therefore this ordinance has been passed. So, therefore, Cooper case, the Supreme Court believed that the genuineness of president's satisfaction is open for judicial review. Of course, immediately after Cooper case, because as it is well known, it was a situation of 70s, particularly the bank nationalization and many other cases were basically on the horizon, and therefore immediately the 38th amendment was passed by the parliament, and that was basically meant to silence the judiciary, because what was done through this 38th amendment was that insertion of clause 4 in article 123, that is ordinance making power, and said that the president's satisfaction shall be final, and it could not be, or it may not be, or it shall not be questioned in any court of law. But in fact, this matter did not end there. And when the Janata Party came to power in 77, and when attempt was made to basically undo all the things of 42nd amendment, and even some other things like this 38th amendment, what 44th amendment did, that it overturned this foregoing clause, and the Cooper case position was restored back, that the president's satisfaction is open for judicial review. Now, what has happened? Therefore, that this ordinance making power is a coextensive power of the president, so far the legislative act of the parliament is concerned. And this is very important legislative function, legislative job, legislative work assigned to the President of India. Now, of course, this has also been, House of People has also made a rule that when an ordinance comes for approval, because as I mentioned that within 6 weeks from the date of the reassembly of the parliament, it is mandatory that it has to be put on the floor, and this has to be approved by the parliament, even if the president has issued an ordinance in absence of parliament in session. But the House of People has made a rule that when an ordinance is replaced by a bill by the parliament, when it is presented to parliament, a statement explaining the circumstances necessitating such ordinance should be attached with it. So, a kind of moral check that one has to, the executive has to explain to the legislature that what were the circumstantial situation necessitated such ordinance. So, therefore, this moral check by the legislature and this judicial check through the Supreme Court judgment in Cooper case are there, but nonetheless this ordinance making power of president is very important. Now, so veto power and this ordinance making power, and then as I mentioned that most of the legislative acts of the parliament are basically done on behalf of the president or through the office of the president, whether money bill or budget or for that matter any other thing. So, therefore, president has important legislative power, but that legislative power is not confined to this parliament, the union, the legislature at the union level. President also has some important power vis-a-vis legislature at a state level, and that comes under the sphere of this federal power of the president. Therefore, in the very beginning I mentioned that office of the president symbolizes two things, parliamentary as well as the federal dimensions of Indian polity. Right now we are discussing this parliamentary dimension. When we will discuss federal, we will also take up this issue that how president has a legislative power extending even to the states. because one thing which one should remember, that the president's election has been basically is normally done keeping in mind this federal parliamentary combination in this office of the president, and that is something quite unique here, that council of ministers headed by prime minister responsible to the lower house of the parliament, of course is head of the executive, that is the union. It is true that the president is head of the state, and when the state is defined here, that state includes both the center and the states, and therefore basically he is also a symbol of federal polity, which prime minister is not, because prime minister is the head of the union executive only. Now, this symbol of president as a symbol of federal polity is reflected in number of features which are basically, or provisions which are there in the constitution. First of all, this electoral college of the president. Who elects the president? It is not only the two houses of parliament, but all the elected members of all the legislative assemblies in India, they are also having the similar votes as the two houses of parliament. Of course, the one thing is important, the elected members. Now, so elected members of all the legislative assemblies in India, that means all the states and some of all the states and the two houses of parliament. And in order to bring a parity between the votes of the legislative assembly members and the votes of the two houses of parliament, a special method has been devised in the constitution, because as it is well known that president is elected through a system that is called proportional representation. It is elected, president is elected, but through a system of representation which is known as proportional representation. And basically it is indirectly elected, because not all citizens of India vote for president, but their representatives who are there either in the legislative assemblies or the parliament, they vote for the president. But what happens here, that president therefore is elected by both the state representatives, the state legislative assemblies and the houses of parliament. And this has been done in order to establish this fact that president, unlike the prime minister, is head of the state and he is the representative of India as a federal polity. He is representing both states as well as center. He is symbol of Indian federalism, as he is also symbol of Indian parliamentary system. So, this combination is quite significant, and because of this, what has happened, as I was mentioning, a special method was devised for his election, that every member, the votes a member of legislative assembly casts and the votes a member of parliament casts, in terms of the weightage, because of this special method of election prescribed in the constitution, the weightage becomes the same or remains the same, whether you are a member of parliament or you are a member of the legislative assembly. While electing the president, the votes cast will have similar weightage. So, therefore, this is quite significant. Now, this federal constituency, so far as this election is concerned, is quite significant so far as this office of the president is concerned. It is a different matter that while in removing the president from the office through impeachment, the state legislatures do not have much say. It is only the two houses of parliament, and that is basically article 61 of the constitution, that is the procedure for impeachment. What happens, that the charges may be preferred by either house of the parliament, not necessarily Lok Sabha, Rajya Sabha or Lok Sabha, either of them. And then before the charge is preferred, what happens, that a proposal is moved, and that proposal basically embodies a resolution, and that is moved after a notice of 14 days. And that notice has to be signed by at least 1/4 of the total members of the house. And then once the charges are preferred, charges stand preferred, then what happened, that such a resolution has to be passed by 2/3 majority of the total membership of the house, which is a very important majority, not a simple majority, 2/3 membership of the entire house. Now, what happened, after one house has preferred it, then what happens, the investigation by other house may take place, or it may appoint a special body to do this investigation. And then if that stage also is crossed, then again the 2/3 of the total membership of that house has to pass it, and if that happens, then the president stands impeached. So, what is significant here, that in appointment, of course, this federal dimension, the federal symbol, president as a symbol of Indian federalism is clearly reflected, but when it comes to his removal, the impeachment, you do not have that that thing available. At least the role of the state legislatures we do not find there. But so far as appointment is concerned, definitely in fact it is very important that president is representing not only the two houses of parliament, but also the state legislatures. But now the question is that this parliamentary dimension of Indian president is to be seen in combination with this federal dimension. And then there are a number of provisions in the constitution which clearly tell you that how they have been combined. Now, of course, this legislative power of the president we have seen, apart from this routine activity of parliament, summoning, proroguing, dissolving, all these powers are there, addressing, sending messages, giving approval to the bills and so on and so forth. But then there are many other administrative actions which are also subject to the president, parliamentary approval, but nonetheless the president has the power to do that. And one such important power is the emergency power in the constitution. And emergency power is also something highly a controversial provision. This has come to Indian constitution from some sources, including Government of India Act 1935. Now, many scholars, many experts and critics, they believe that it is a kind of is a black spot on Indian democratic polity, because what happens that during emergency fundamental rights are suspended, the democracy is suspended, the polity does not look like a democratic polity. Therefore, it is believed that it is a kind of black spot. But nonetheless, those who are the supporters of this provision, they believe that it is a extraordinary, or one can say a noble invention by the Constituent Assembly. Because what happens that in certain emergency situations, in certain contingencies, certain eventualities which cannot be imagined, what happens that without taking recourse to war, as perhaps Abraham Lincoln had to do in the United States of America, the Indian president can meet those challenges through the constitutionally mandated law and rules and provisions. And therefore, when the situation is overcome, then again the polity can come back to its normal shape. So, therefore, it is a very good innovation that for on certain moments, certain situations, when there is a requirement for extraordinary remedies, extraordinary actions, then this emergency provision can come handy. So, therefore, you have both the supporters as well as the critics, but nonetheless, as the constitution is concerned, constitution is very clear that there are three types of emergency provisions in the constitution, emergency powers, and it is the president who has the power or has basically been given this role to use this emergency power. They are Article 352, Article 356 and Article 360. The 352 is called national emergency. The second is 356, it is normally called a state emergency, or in common parlance it is also referred as president rule. And the third is 360, which is called financial emergency. Now, let us start with this national emergency 352. Of course, the basis on which this national emergency can be promulgated is basically war, external aggression and armed rebellion. This internal disturbance clause was omitted and substituted by armed rebellion by the 44th Amendment. As it is well known that 75, on basis of this internal disturbance, national emergency was promulgated in India. So, therefore, when 44th Amendment tried to undo some of the things of the emergency years, then one of the things which it did, apart from many other things, was replacing this internal disturbance with armed rebellion. Now, what national emergency is all about. Now, national emergency can be promulgated by President, of course, on the advice of the Council of Ministers. And it is here that the Council of Ministers, the term does not occur in the Constitution, rather it is the Cabinet. The Cabinet has to recommend this emergency and the President will promulgate it. Of course, the power to promulgate lies with the President. And here I think this aid and advice thing comes into picture, because normally the President acts on the aid and advice of the Council of Ministers. So, therefore, when the Council of Ministers, or one can say the Cabinet, advises him to do so, the President normally does this and promulgates emergency. When emergency is promulgated, then what happens, that within a 1 month period, Parliament has to approve it, this act of the executive, and therefore, here the legislature executive action is subject to legislative ratification. Now, what happens, that this approval of this act of executive is a majority of majority of the total members, as well as the 2/3 members of those who are present and voting on that moment. So, therefore, it is a special majority, that total majority of the total house, that is 50 plus 1 plus 2/3 of those who are present at that moment. So, therefore, within 1 month they have to approve it, and then this will stand approved. Now, of course, the 44th amendment, as I mentioned, that replaced internal disturbance with armed rebellion, also made some changes and gave a provision for revocation of emergency by the legislature, and it says that 1/10 the members of the Parliament can give a notice through a special session, and once they give a notice, a special session may be convened, and that session, the special session may be convened in 14 days, and when this revocation resolution is put to vote by simple majority, present and voting has to pass it, and this emergency will stand revoked. So, therefore, now this power also lies with the legislature, which was earlier only with the executive to revoke it. Now, the legislature can also revoke it. So, this is 44th amendment. Now, what are the implications of this emergency? That is quite significant. Now, the most important implication is that some of the fundamental rights get suspended. Now, what are the fundamental rights get suspended? Under Article 356, under 358, what it says, that when the national emergency is promulgated, Article 19 is suspended. Even in Article 359, it is also mentioned the right to move court can also be suspended by the order of the President, but the President will have to issue a special order for that. Now, of course, the Article 19 is suspended only when the national emergency is promulgated on basis of war and external aggression, and therefore, but the move to court can be suspended on basis of any of the three, that is armed rebellion, war and external aggression. Now, 19 gets suspended automatically, that 19 all types of freedom which are basically the fundamental rights guaranteed to the Indian citizens in the Constitution, they get automatically suspended. But under 359, if apart from 19 the President feels that there are certain other fundamental rights which need to be suspended, then President has to give a separate list of those rights which need to be suspended, and that is mandated under Article 359, that they will not automatically be suspended, but President can basically can give a list of those rights which need to be suspended under 359 during national emergency. Of course, the exception is 20 and 21, that is right to life, freedom. They are very important, and therefore, they cannot be suspended. And it is here this habeas corpus becomes very important. Now, what I am basically trying to say, that this national emergency is one important power of Indian President, that when this entire democracy gets suspended and the executive becomes so powerful, and all these acts may be done on the advice of the cabinet, but nonetheless these powers are exercised by the President of India. The second important emergency power is basically 356, and this is also called a state emergency. and this is one provision about which it is said that this has been misused more than any other provision of the constitution, because there was a time when there was no judicial check, there was no moral check, and therefore mindlessly political parties and the power at the center used to use it against adversaries or any other party which had a government in various states, and therefore no party was an exception, and therefore whichever came to power at the center and found that the state government was under control of some other party, then invoked Article 356 and dismissed the government on this plea that they have lost people's mandate, and therefore they have to again go to the people to renew that mandate. So that was the basis, though later on it was argued that it was not a convincing ground for dismissal of the government under 356, because 356, so far constitution is concerned, is also basically hazed with a number of other provisions, including 365, and 365 basically says that the center has to give directive to the states, and if the state defaults on that, if doesn't comply with that directive, then it is basically liable to be punished, and that punishment can take place under 356, that is constitutional breakdown. So definition of for invoking 356 or the basis for invoking 356 is a constitutional breakdown in the state, and if there is a constitutional breakdown, how the president would know about the constitutional breakdown? President would know it through his agents in the state, that is the governor, because governor basically is appointed by president, he is in the office due to the pleasure of the president till he enjoys the pleasure of the president and acts on his behalf. Therefore, the governor, when reviews, assesses the situation and find that there is a constitutional breakdown, and when he reports to the president will impose Article 356, that is state emergency. Now, the provisions for the parliamentary ratification is different in 356 compared to the national emergency under 352. Now, in 352 we have seen that the parliament has to approve it within 1 month if it has to continue, but in state emergency, that is constitutional breakdown 356, the approval period is 2 months. But in fact, if the parliament is basically dissolved, is not there, then in case after reassembly this becomes 1 month, that in normal situation 2 months, but if the parliament is dissolved, at least the Lok Sabha is dissolved, then once it reassembles, then within a month it has to approve it. Now, when it is approved, it will be there for 6 months in one go, I mean at a time only for 6 months. Approval means that this will continue for 6 months, and then the maximum time period prescribed in the constitution is 3 years, but over if it is to continue for more than a year, then only 2-3 conditions, it has to satisfy 2-3 conditions. The first condition is that there is already a promulgation of emergency under 352. Number 2, the election commission certifies that the situation in the state doesn't permit the conduct of election, and in that situation it can continue for more than a year. Otherwise, within a year, if state emergency is imposed, then the election has to be held in that particular state. Now, what happens therefore, that this 356 has drawn the attention of both judiciary and basically the scholars, as well as various commissions and committees which have come to review the functioning of Indian democracy and Indian federalism, most importantly the Sarkaria Commission. And what has happened, that after the famous Bombay judgment of the Supreme Court, what has happened now, that this 356, now there is a check on that it cannot be mindlessly imposed. It cannot be imposed due to the whims and fancies of the party in power at the center. There has to be some objective consideration, there has to be some material evidence to support this constitutional breakdown, and then only this 356 can be invoked. Even Sarkaria Commission believed that if Indian federal polity has to basically become vibrant, then there has to be a selective use of 356, not this excessive use as it has been done. So, this is what normally you understand by this article 356, that is a state emergency. Now, what happens that the third type of emergency is the financial emergency, and it comes under article 360. Of course, till now no such occasion has arisen, but what happens that all money bills of the state are reserved for president when financial emergency is concerned. Of course, so far as the money bill in the parliament is concerned, the president himself moves it. So, naturally there is no question of withholding it, but so far as money bills of the states are concerned, they are basically reserved for the president by the governor. Then Supreme Court and High Court judges' salary may be reduced, and if their salary may be reduced, then one can imagine the salary of the other functionaries of the state. And then there are also there is also provision of legislative approval, like the other two emergency powers, that is national and the 356, that is constitutional breakdown in the states. And here again, like 356, the provision is that within 2 months the parliament has to approve it. Now, what I am basically trying to say, that this emergency power is also a matter of grave concern so far as Indian democratic polity is concerned, and it is argued that the president is a symbol of Indian federal system as he is symbol of the parliamentary system, but these powers are there in the hands of president not to promote or make federal polity more vibrant, but rather to strangulate the federal polity, in the sense that most of these powers militate against the spirit of federalism, and they work against the state legislatures and state executives, including article 356. So, therefore, what happens that the president power, emergency power, is another important power, though may be controversial, but nonetheless important power, and one cannot put it as purely legislative, but executive power ratified by the legislature. So, therefore, this legislative power we have discussed the vetoing power of the president, we have discussed the emergency powers of the president. Now, then there are many other different types of power, and they are called the miscellaneous power, one can say. He is head of the three branches of the defense forces. He basically can declare war, he can do treaties. Of course, the council of ministers does, but basically everything in name of the president, as it is believed that president reigns and the prime minister rules, but nonetheless everything in his name. What happens that he appoints governors, he appoints members of the Union Public Service Commission, he he makes important appointments of diplomats and ambassadors, and unlike United States of America, there is no senatorial courtesy, that all important appointments after they are made by American president, they are subject to Senate's approval, and it is called senatorial courtesy. But in India there is no such courtesy required. So, the Indian president has umpteen number of powers so far as appointment of important dignitaries of the state are concerned. Then he has a special responsibility towards scheduled castes, scheduled tribes, other backward classes, weaker sections, and so on and so forth. And therefore, from time to time the president can institute a commission to investigate their conditions, and therefore the president of India appointed 2 commissions, one by Kaka Kalek and another Mandal, to investigate the conditions of the other backward classes. Basically, president can also appoint commissions on language, interstate council, and so on and so forth. And therefore, the president, one can say, that has number of powers so far as the appointment is concerned. Attorney General is appointed by president, governor is appointed by the president, judges of Supreme Court and High Court are also appointed, but nonetheless now you have a collegium system where the senior most judges, they decide and then they recommend the names, and then the president basically approves it. So, in fact, the new initiative of the parliament to have National Judicial Appointment Commission has been turned down by the Supreme Court, and therefore this collegium system now stands. And in that, of course, the appointment is decided by the collegium, but nonetheless appointment is made by the president. He appoints the election commissioners, and therefore of course, he can remove the election commissioner also on address of the parliament. So, therefore, president had number of powers so far as removal and the appointment is concerned. The governors, of course, is at the pleasure of the president, and the pleasure itself is a debatable issue. So, what is the pleasure? Like article 356, this pleasure doctrine of the president has also been misused by the party in power at the center from time to time, that whenever there is a change of government, governors are recalled, and this pleasure has now basically been challenged also in the court, that how this pleasure can be used without any substantive basis. Withdrawal of pleasure can be used without any substantive basis. So, therefore, what we find that president has number of powers so far as appointment, removal, etc. concerned. Now, of course, it is also required that the previous sanction of the president is required for legislative action, and on certain matter this is mandatory, particularly when a new state is to be formed. Only recently Telangana was formed. Before that the 3 other states were formed, Uttarakhand, Chhattisgarh and Jharkhand, and whenever the new state is created, the formation of new states or alteration of the boundary of the existing state happens under article 3, then what happens, that president is also mandated to obtain the views of the affected state, and the purpose for it is being done, the president is empowered to do it. Now, of course, then the president has number of important other powers related to the pardon, and this is quite significant. Of course, like president, the governors in the states also have the pardoning power, but the president's pardoning power is significant because on all cases related to the death sentence, only the president of India has a power. President has also power on all the judgments of the court martials, and then president has also the power where the executive power of the union basically extends, but so far as the death sentences are concerned, basically only the president has the power, no one else has the power. So, I mean, these powers and the positions therefore tell you that president of India has number of powers, and basically those powers basically extend to both federal as well as parliamentary sphere. Now, as I mentioned, that president is a combination, this office combines the features of both federal and parliamentary. We have discussed extensively these parliamentary features of Indian president. But so far as federal features are concerned, which is reflected in the election, but then there are other important dimensions of this federal feature, and therefore what we find that whenever the state legislature passes a bill, what happens that the president has the power to disallow or return such bills for reconsideration, and it happens only if it is reserved by the governor for presidential assent. Now, what happened that this power is something quite unique in India. No other federal polity perhaps has such such provision, except perhaps Canada, where the governor general can withhold the assent or in fact can disannul legislation, even if it is reserved for his assent, even if it is not reserved for his assent. So, in Canada one can find some similarity, but an Indian president nonetheless is sometimes uses this power, which is unheard of in a federal polity. That what happens that even if a state legislature passes a bill and that bill is reserved for the governor, thus basically the president has the power to simply not give assent to it, can withhold his assent and can also send it back, and the state legislatures within the 6 months time period have to reconsider it, but after reconsideration it is not obligatory on the president to basically approve it, and therefore because of there is no time frame prescribed here, the president has this absolute veto on the state legislation, and this is something quite unique in India, and therefore many people believe that India is the only federal polity in the world where the president has such power, the head of the state has such power on a state legislature. So, therefore, in fact, in case of this federal dimension, a federal dimension of Indian polity, we find that a president exercises many powers, and those powers are not at times meant to make federal polity more vibrant or to basically increase the strength and the powers of the state legislature or the state executive. Rather, they are mostly meant to strangulate the powers and the prestige of state legislature. So, therefore, this federal dimension of president has also been critiqued by a number of scholars, saying that such provisions do not augur well for the health of a federal polity. Now, so far the position of the president is concerned, in fact, it is highly controversial matter that what is the position of the president. And as I mentioned in the very beginning of my lecture, the first president of India, Rajendra Prasad, himself expressed this opinion that since Indian president is elected president, this entire office is basically a reflection of people's mandate, even if it is indirectly elected, but nonetheless it is elected. Therefore, one cannot say that it is a carbon copy of the British monarch, meaning thereby that the Indian president has some real powers like the executive head of the government in United States of America. But it is to be remembered that in the Constituent Assembly there was lot of hesitation in going for this elected presidency, because they all were apprehensive that there may be the conflict of interest, the conflict of positions, because putting two elected heads, one the head of the state, another head of the government, both elected, may create a kind of problem today. Sometimes we witness when the president's office of the president expresses such views. And this did not stop with Rajendra Prasad. I told you that it came up again and again even later. Now, of course, in the famous Cooper case I mentioned earlier, so far the ordinance making power is concerned, the Supreme Court expressed its opinion very clearly that the president is the constitutional head, and he has to act on the aid and advice of the Council of Ministers. And this Article 74, that is aid and advice, is very important. That basically that makes president only a constitutional head. In fact, maybe symbolically everything is done in his name, but effectively it is the Council of Ministers which has to basically run the administration and the government. Now, in the Samser Singh versus the Punjab case, also the similar opinion was expressed by the judiciary when the president was declared the formal head of or the constitutional head of the government or the polity. But I think this matter acquired more prominence when India moved from the one party dominant system to the coalition era, and with the weak government at the center, with the fractured mandate of the parliament, the office of the president again acquired lot of salience, and such issues started coming up. So, this is totally unsettled matter, but nonetheless till now one can say that the president has functioned as per the constitutionally mandated role, and therefore in fact he performs very important role so far as federal parliamentary polity in India is concerned. I will stop here.
With this note, thank you, sir. Thank you so very much for giving us a detailed outlook and a detailed perspective on the Indian executive and the president, the way you delivered the lecture by introducing various elements and describing the powers of president. Dear friends, we hope that you might have liked this lecture, and if you want to give your feedback or you have any kind of queries or questions or any topic which you like that it should be delivered through this EduSet platform, then you can mail us at info.cc@nic.in. We would love to take your queries, your feedback the next time when Dr. Satish Jha visits our studio once again. Till then, take care, goodbye, and yes, keep watching us with the help of YouTube, because we are going to upload these lectures very soon on YouTube for your convenience, for your study. With this note, thank you so very much. Thank you, sir.